Hi everyone, welcome back to the channel. I hope this video finds you well. Right first thing in the morning, I got some good news for you in that we have a landmark decision out of a district court in Virginia. The judge's name is Robert E. Payne, and this case is Fraser versus ATF. And this is important because we've seen recently Congress move to eliminate the rights, the Second Amendment constitutionally protected, God-given, inalienable rights of 18 to 20-year-old American citizens in the Bipartisan Safer Communities Act. Well, basically what these gentlemen did was challenge the prohibition on sale of handguns to individuals under the age of 21. If you're not tracking to buy a handgun in the United States lawfully from a dealer, you have to be 21 years of age. As a federal firearms licensee, if a 20-year-old shows up to my shop and says, hey, I want to buy a handgun, I can't sell it to you, right? I will lose my license over that. What this case does is bring that into focus and challenge it. And boy, oh boy, is it a good one. So get your reading glasses. I'm going to do a fair amount of reading in this video, and I'm going to hop around a whole lot because there's over 70 pages of this just fantastic analysis by this judge. You're going to love this one. First off, the ATF tried to pull a fast one in this one and say that these guys don't have standing because, well, they can receive handguns as gifts from relatives and other people. So check me on this one. Make sure that I'm tracking right. The ATF just insinuated that they don't have standing because since they can't legally purchase a firearm, they have the capacity to just solicit that purchase for them from other people who could. Really? Really? Anyway, judge's like, yeah, right. That's not going to work. And after a few pages of analysis, the judge goes on to say that the plaintiffs have suffered an injury in fact, and this is concrete and particularized and actual or imminent. And they have met all of the other requirements. Accordingly, they have standing to bring this action to court. And then for a decent chunk of pages, the judge goes into the Second Amendment, Bruin, Heller, and McDonald. And he concluded that keep and bear arms in the Second Amendment includes a right to purchase. Every town for gun safety requires the court to consider the definition of the people at the time of the founding. The government argues that Congress has the authority to select the minimum age to directly purchase a handgun, and it is within Congress's authority to vest this right at 21 because the Constitution establishes only one right that vests at the age of 18. Voting. However, Firearms Policy Coalition v. McGraw and earlier this year, the District of Minnesota determined that those aged 18 and up are part of the people. Worth versus Harrington looked to the normal and ordinary meaning of the people and determined that it included all Americans who are part of the national community. Because if you didn't go with that, you would have to go with the historical interpretation of the political community, which I don't think is going to go over very well, because it would only include white landed men, the lauded independent yeoman farmer. Like I said, I don't think that would go over very well. So are 18 to 20-year-olds members of the political community is the question. The founders often used age limits to restrict access to certain things within the government, and this was put on display in this court decision. For example, they imposed age limits on the right to hold offices, and later amenders twice referenced age in terms of voting. From these facts, we know that when they thought it necessary to do so, the founders used age to regulate access to important rights. He goes on to explain that the fact that they didn't mention anything as it relates to gun rights doesn't help us out here, so we have to dig a little bit deeper. And after several pages of analysis on the topic, he concluded this. If the court were to exclude 18 to 20-year-olds from Second Amendment's protections, it would impose limitations on the Second Amendment that do not exist within other constitutional guarantees. It is firmly established that the rights enshrined in the First, Fourth, Fifth, Eighth, and 14th Amendments vest before the age of 21. Like these other rights, the Second Amendment's protections apply to 18 to 20-year-olds. By adopting the Second Amendment, the people constrain both the hands of Congress and the courts to infringe upon the right by denying ordinary law-abiding citizens of this age the full enjoyment of the rights to keep and bear arms unless the restriction is supported by the nation's history. That is what Bruen tells us. So because it is Second Amendment conduct, he says that we now have to go to the history to determine whether there is a basis for regulation by the government. So what does history say? Militia laws. The militia laws and the record do not support a finding that prohibiting the purchase of handguns by individuals between the ages of 18 and 20 comports with the nation, history, and traditions. Although the District of Columbia v. Heller determined that textually the right to keep and bear arms is unconnected with militia service, the age of a militia enrollment is relevant in helping determine the history and tradition of firearms regulation. The fact that an individual could or was required to serve in the militia indicates that society believed that he lawfully could and should keep and bear arms. Furthermore, because militiamen generally were responsible for providing their own firearms, it is logical to conclude that 18 to 20-year-olds were not prohibited from purchasing them. I think I love this man. If we move forward a bit, the government has presented numerous examples of militia laws from around the time of the founding, but notwithstanding the volume of historical material, the government has failed to demonstrate that 21 was the age for militia service. Instead, the historical sources show that at the time surrounding ratification of the Second Amendment, 16 or 18 was the age of majority for militia service throughout the nation. On June 8th, 1789, the date Congress proposed the Second Amendment to the states, 10 of 13 states specify 16 as the age for militia duty, and the other 3 were 18. The judge even went as far as to point out that families could be fined for not properly equipping their levies. And it goes on and on and on. Conclusion. Under the analytical framework established in Bruen, the government simply has not met its burden to support the findings that restrictions on purchasing of firearms by 18 to 20-year-olds is part of the nation's history and tradition. Founding-era militia laws provide circumstantial evidence that 18 to 20-year-olds could purchase, own, and use arms. These militia laws and the cases interpreting them further support the findings that 18 was the age of majority for acquiring and possessing firearms in the founding period. There is no direct evidence of age-based firearms restrictions. The government, the party which bears the burden, fails to point to any founding-era laws to support the challenged law and implementing regulations. The only laws it can point to date from more than half a century after ratification, and that does not discharge the burden in Bruen. God damn. By prohibiting the ability of individuals to acquire or possess arms, those regulations cross the bounds of a presumptively constitutional commercial regulation to an impermissible infringement on the Second Amendment. Because the statutes and regulations in question are not consistent with our nation's history and tradition, they, therefore, cannot stand. Can I get another slow clap, folks? So what does this mean? If you're an 18 to 20-year-old, can you just go to a FFL tomorrow and buy a handgun? No, unfortunately, it doesn't. Although they did name 18 and 20-year-olds as a class in this lawsuit, which is fantastic. So it's a nationwide thing. What has to happen in this instance is that the regulatory agency then has to rewrite the regulations governing this. And given that the regulatory agency, the ATF, is the defendant in this case, they're going to appeal this. And here's the situation with that. We now have differing opinions on whether an 18 and 20-year-old can possess or purchase and possess a handgun. So we have other decisions that say no. This decision says yes. And you know what that means? This is at a district court level. So that means it has to go to the next level. which is going to be an appeals court. And then more than most likely, it's going to the Supreme Court. Okay, so this is not yet fully decided, but I'm going to guess that you're going to see some traction in this in the next couple days. You'll probably see some kind of appeal by the ATF to the next level, and we're going to have to cover that as it happens. So what I would like to know from you guys is what you think is going to happen. Sound off in the comments section down below. And if you think that this is a fantastic ruling, then I want to see that thumbs up. Thank you all for joining us here today, and hopefully we'll see you on another video here at the VSO Gun Channel.